presentation. This will take about an hour. This is usually about an hour and a half, depending on questions. Let me see the chat just to make sure you all can hear me. Great, you can see and hear me, wonderful. On the screen, I'm going to share my screen. There is a sheet. And so today we're going to be talking about estate planning. If you're not here, want to learn about estate planning, then you're in the wrong room. But the idea here is I've got about 20 years plus of experience. I'm an estate planning attorney. I also do business planning. That's our core competency of our firm. And so this presentation is about going through process on estate planning, common pitfalls, what you need to look out for, current issues that are out there today. One of the biggest issues today in estate planning is long-term care issues, dealing with a loved one's disability, and how do you think through that issue, and how we work with clients, how we charge. And so it's more of an overview. This sheet that you should have received as a handout is what I would call is the consumer reports of estate planning attorneys. These are the questions that I would be asking an estate planning attorney if I was in the market for one. Everyone asks about price, which is important, okay? But there's about 14 other questions you need to be asking the attorney, okay? And so most people just don't know what to ask, and at least you'll know why we're asking the questions, and you'll know our answers at least, okay? And so I'll check back in towards the end of the talk today, and we'll go through that. All right, so we'll get started now. And so I'm Bobby Fazy. I'm president of Insight Law. Do estate planning and business planning. 60 to 70% of our clients, estate planning, 30%, 40% business planning. We don't do litigation. We don't do personal injury, right? This is our core competency. You'll find that if you work with me, I'm a very blunt attorney. Most estate plans just don't work. And what I mean by that is you may have a will or a trust, or you might have done some planning before, but the plan, the way I look at it, I take a very practical approach as far as if the plan will work or not. Your plan, you want to think about what's your snapshot you want it to look like, right? I kind of begin with the end in mind. So the thing that I ask our clients is, okay, think about the time after you've passed away and you're looking down from your cloud from above, right? All my clients look down, they don't look up. It's the alternative. But the idea is with money going, if money's going where you want it to be going and people doing what you thought they'd be doing, then that's generally a plan that works. Okay, but if money's not going where we thought it would be going and things not happening the way we wanted to do, court or a bunch of expenses, it's probably not a plan that you thought was going to work. And so I find that people don't have a real clear picture of their snapshot. Today, hopefully from my perspective, I'll say, here's some things that might clarify your snapshot from what I do how I work with clients, okay? And there's some typical traps and pitfalls I see people fall into is they focus on the documents. Okay, what documents do I need? A will, a trust, medical directive, power of attorney. I'll go and explain, those documents. They're just the lawyer's tools. What you really want is when something does happen, right? If there's a death occurs, or if there's a major disability, that you have a plan in place, and the documents just don't jump off the shelf. It's going to be family dealing with it, that they know what to do at that time, and they can rely on, hopefully they can rely on resources to get them through that. My analogy for the different legal documents that lawyers use in the estate planning world, my analogy is like a carpenter with their tools, right? I'm a big fan of the show, The Fixer Uppers. It's just a show that goes through, a couple goes to houses and renovates them. Joanna's the one who sits down with the clients and says, what's your vision, your goal? What do you want to accomplish, right? How do you want the counters to look like, the kitchen to look like? And Chip is the carpenter who comes in with his tools. And so the point of that analogy is, does anyone ever ask Chip what type of tools he is using to create the countertop or the like, or whatever, the carpenter? And so the lawyer's tools are the documents. It's not the legal document. Did it work, right? When something happened, did our family get through that without having a big mess on our hands? And so that's one thing. So yes, the documents are important, but that's not the only thing. I can arrange a plan in many different ways, depending on your goals and how your specific financial picture looks like right now. Taxes, okay, that people say, oh, I don't have a big estate, so that I don't have a taxable estate, so there's no need for planning. Taxes is one issue. Hopefully by the end of discussion today, I can tell you, you'll see, oh, that's one of 4 or 5 issues. Okay, that's an important issue. And also the tax landscape has changed. If the estate tax does apply to you, great. I mean, and there's going to be some changes on the horizon. So you should be aware of the laws and what to look out for. A lot of times on the tax side, now you're dealing with, there's new rules for what's called your retirement plans, like qualified money, IRAs, Roths, 401ks, traditional. So now with legislation called the Secure Act, they have impacted the way you designate your beneficiaries on that. So it's not just a very narrow focus on tax. You have to look at what the playing field is. And do you have a business? Do you have real estate? How do these things work with your planning? The transfer trap. So the transfer trap is you just want to avoid probate, okay? And probate basically is a legal proceeding, okay? That is a court. The analogy I use, it's like a government audit of your estate after you pass away. They want to know to a penny what you die with, account for any, notify all heirs, even if they're not listed in the will, notify all creditors, and let them have their day in court, and then account for every penny of income, and then distribute it out to the beneficiaries, but showing the court to get approval for that. So, and especially with the way things are going now, it's really slow in court. Can you imagine with all the stuff with the health issues, is that it just takes a long time, it's expensive, and it's completely avoidable if you plan your affairs right. It's just people don't plan things right. I'll show you how you can do it. And that's one of the points of the education today. All right, so the main thing is just knowing what's really missing for people is that they get focused on these kind of red herrings, right? So they all are important, but you have to look at the overall plan. And so sit down with someone who could say, okay, this is what your situation is. Here's what you want to accomplish. Here are your options with regard to it. We'll get to the documents to facilitate that, but I'm not just going to start with a document without knowing what you want going. So there's the picture is fuzzy. That's my thing there. And then we're going to make it clearer throughout today. So one of the first questions that you want to know and be comfortable with, we're talking about estate planning today, is I would ask the attorney how they define estate planning. All right. And so you should have a good idea what am I doing here when I'm defining, doing estate planning. I define it as follows. It's not my definition. It's the National Network of Estate Planning Attorneys definition. It's not in Webster's dictionary or Black's law, but I like it. It covers all the issues. It says I want to control my property while I'm alive and well, right? Control while healthy. We're just building a succession plan, right? A plan for me, my loved ones, if I become disabled, mental disability, and then hopefully it never happens to you, but it's becoming a bigger and bigger challenge today, okay? So control while healthy, plan for disability, and then I want to give what I have to whom I want, when I want, in the way that I want. Okay, a lot of people don't know the different options that they have. I'll show you some sample options today. All while assuring my wisdom is transferred along with the rest of my wealth. I try to set the bar high where let's pass on the values if we can. And then in the estate plan is the best place to leave a gift if you can. Not everyone takes, my goal is to raise the issues and you take what you like with regard to it. This planning pyramid is basically our counseling philosophy. So the idea with this pyramid is that, when anybody who walks through our door for counseling, this is our approach, is first we want to get to know who you are and the family situation. Like, what are your goals, right? What do you want to accomplish with the plan? And then what's the family dynamics? So are you married or not? If you're married, how is the spouse with finances? How is the spouse with health? Who pays the bills? Get kind of that lay of the land down. Do you have kids? If you have kids, are they minor children or are they adult children? Whole host of different issues for minor children than we have for adult children. Are there any special needs or health issues we have to be worried about with regard to the kids, or any government benefits or issues that we have to be aware of? Okay, once I know the lay of the land, like in the family issue, like maybe a spouse is dealing with a long-term care issue, or there could be one on the horizon, right? And so that's a goal that I need to understand. Okay, this is the landscape. There's a health issue. So now, what are ways that we can do to preserve the wealth of the family? That's one of the biggest issues that are out there. Hey, can we protect what we have, and also expand wealth if there's opportunities? And saving taxes is definitely important, but that's not where we drive or start with. Thank you. That's not where we start the conversation. Is once I understand the landscape, then we can make recommendations. And if you do have a financial advisor that you work with, this is a great kind of approach to it, where they are the financial advisors are the experts on the wealth, right? Managing the wealth. And so making sure that the attorney and the advisor, if you do have one, that we're communicating, that brings a lot of value to your planning. Okay. And so that's the typical approach to it. And so basically, you teach us the family, we'll teach you the law, right? And together we'll make the plan work. This is, I'm a bullet point person. And so these are the 4 bullet points that if I'm reviewing a plan, and if you're looking at your plan, if you have one, or if you're in the market for one, here are things that I would say every good plan will have these 4 items check off. The last one has a couple of subparts, but number 1 is, did they get good personalized counseling? Did someone sit down and go through options with them, or did they just get biographical data? Yes, I spelled counseling with 2 L's. I'm trying to make a point, like my counselor at law degree from the state of Virginia, the bar, that means that there's something more than me just typing some things into a word processor, right? And so I'll give you examples of some sample things that we do there. Number 2 key issue is proper asset ownership, right? This is probably one of the biggest pitfalls in estate planning, is that people have this idea or have set these instructions in place, or they think they have set these instructions in place. But the way assets are titled, that will trump actually the legal documents. And so titling ownership of your assets will trump how the legal documents are kind of laid out. And that's a very important deal in estate planning, because when you think about it, I'm really someone who's able to, at least with a lot of your assets, structure things so they're as seamless as possible on major life events, right? Those big roadblocks or speed bumps, disability or death, right? So how do things get moved? What's the best way to have the asset owned before those happen? So there's a least amount of hassle, least amount of taxes, most amount of protection. There's only 3 ways you can own anything, okay? So it's your individual name, jointly, and by contract. And I'll explain those different options. And then having some type of formal review process. We just live in a time where this is change is what's consistent, right? Change in administration, change in the laws, different financial techniques. So the plan just needs to be fluid, and we'll go through our approach to that. Most people just don't want to pay an attorney hourly, because once you set it up, that's how most attorneys will normally do it. We don't take that approach. We just have a member optional maintenance program that you can take advantage of if you want. It's a flat fee, and we'll go through that. And then a controlled transfer process. You probably wouldn't be bothering listening to me today if you didn't want some type of controlled transfer process, right? So I'll get blunt again with you. If you were to die today, how prepared is your family if something were to happen to you today, right? The plan's got to work every day, because you don't know when you're going to pass. And and what I mean by a controlled transfer process is, do they know what to do? Does anybody know what to do for your plan, right? Do they know how to do it? And do they know how to pay for it? And so if you've got those 4 bases covered there, then you've got a good plan. And so I just have a review process, and that's what I do every day. It's a mental checklist to go through those things. There's 5 options out there as far as planning. Okay, in my mind, there's 5 ways you can do planning. You can do no documents. That's not a good position to be in, because there's a lot that will actually cost the family more in the long run. You can do a will, and a POA stands for power of attorney. So you can do a last will and testament and a power of attorney. You can do a will with, The power of attorney, by the way, there's a couple different flavors of powers of attorneys that are out there. There are financial powers of attorneys that allow you to appoint people to manage your financial assets for you. And that's a basic legal document, but there's two different types. There's two types of subcategories categories of financial powers of attorneys. There's general durable powers of attorneys, which are effective when you sign them, okay, and they're effective immediately. And so the agent can do, which you can do as an effect you. That's a lot broad power to have effect immediately, but that may be fine for your family. You just need to be counseled on the legal ramifications of it. There's also something called a limited and miscellaneous power of attorney, financial power of attorney. Some people will call it a springing power of attorney, which doesn't take legal effect until after you've been determined to be disabled, okay? Eventually gets you to the same place, but there's a hoop before you go to that. And so that's just options that you need to go through and see what you're more comfortable with. What we do at our firm, a little bit belt and suspenders, we do both, but we don't give you the general, we escrow it. And so someone's kind of got to come to us before we release the general one. The limited one is out there in the world, and as long as you're determined to be disabled, great. It'll work for the financial assets. The other side of the power of attorney is your health care power of attorney. So different jurisdictions will call it different things. A medical directive, it basically does two main functions on the medical directives of the healthcare powers of attorneys. Designates your healthcare agent to make decisions for you when you can't communicate them to the doctor, okay? And what I find there is a lot of people don't have, their healthcare agents don't really know what the person wanted because they never really talked about it. And so our goal is not only just to document it in a medical document, but that's a sterile legal document saying you're my agent, but also, going through some checklists and the like so that you've had the conversation with that person so that they know what you would want. And at least we've got the checklist documented in the file. The other component to the medical directive is the living will. Some people call it the pull the plug document, right? And so that's one of many medical decisions. Hopefully we're not going to the pull the plug right away, okay? Unless that's where you're at in life, where I don't want to be revived, right? But most people want to try and want to do a lot of different things before that last decision. And so make sure that we know in what circumstances is that something that we don't want to be kept alive that way. And then a will with a testamentary trust and a power of attorney. Kind of stay with me. A last will and testament. A testamentary trust is one that's created after death, okay? Not one that's created during lifetime. And there's court oversight and management of that. I'm not a big fan of that. I don't know why you want to involve that. I mean, if you had an issue where you're worried about litigation in your family and you just wanted it to go to court, great. But if you don't have to go there, let's avoid it on that side. I see a lot of simple trusts that are out there, things that are just done online, or that you know what an attorney is going to charge you for your trust because they put it on their site. I don't know how anybody can charge you for something that they don't know what is your specific situation. And so you're just getting a word process document, right? If they're saying this is what you're going to get this, I don't think that's the good approach. Our approach is a modern approach. Sure, we use trusts a lot because those are a great way to use control. But that's just one tool, and there's some a lot of customization with regard to that. Okay, it's the process that matters. And so, in my mind, our mission at Insight Law is very clear, and we talk about this at our team meetings. Is that when we receive that call, it's really clear what our underlying mission and goal is, which makes our lives easier. I think in a way, is that. We get the call that someone has passed away, one of our clients had passed away. We want to be able to say, everything's in good order on the legal side. Just be with the family. When you're ready to come in, you're going to get priority, and we'll have the initial settlement conference. We have a specific process to get through that. We'll lay out roles, responsibility, how the fees work. If you want to utilize us, we have that process in place. We've done over 50 administrations, okay? So we know what we're doing and we know it works. And that's kind of the driving mission. They don't want to hear, we think your plan is in good shape. We haven't heard from you in a while. We don't know where any of the assets are or know what your latest instructions are. If it complies with the law, it might work. And so that's the way it typically is done, is that people do it very transactionally, and they have no ongoing follow-up or relationship with the attorney in just a basic way, so that when something happens, we can just get you through that process efficiently as possible. And so that's the idea. Everything in the middle, I think, is bare bones planning. The other stuff, no documents is no planning. And so I'll go through some of the major challenges. So today in estate planning, the major challenge is mental disability. If you're younger, you're not thinking about that, but to be blunt, right? The mental disability occurs and you're dealing with a loved one's long-term care issue. I had a personal experience with my dad, had something called Lewy body disease, form of Parkinson's that caused dementia. And so it was a gradual deterioration of his mental abilities over 10 years. And so the thing there is that if you're disabled, to be blunt, when you're dead, you're not here, right? And so there's no ongoing issues. If you're disabled, now there's a whole host of other issues that are there than if you passed away. So if there's an issue for the family, what type of health care are you getting? Where the level of care? Where are you getting the care? Home, hospital, nursing home? Who's giving it to you? What's the cost of the care? What is covered, right? What's coming out of the estate? So there's a lot more, and then who's doing it? And so it's a family issue, and there's a lot more time and expense involved with that. And if you're younger, you're not thinking about that, or if you have family members that are dealing with it, personal experience just one time is enough where you'll get to know that is a serious issue. And then asset transfer on death, making sure that there's no court or making the financial institutions making you go through a bunch of different hoops to get assets transferred from one place to another. And the taxation. Taxation, of course, let's minimize taxes to the greatest extent possible. And then making sure personal planning goals that your plan achieves what you want it to do, what you want to accomplish. Our approach to it, okay, this is not the only approach out there. I like this approach. This is the one that resonates with me. I was taught this through the national network. I'm an instructor at the national network. And so it's just a 3-step approach, okay? Empowered design. And the ideas behind it is, let's not just get the biographical data. Let's make sure we do the critical thinking up front, which will provide huge value down the line. Okay, and because I've seen it all the way through the end, work again and again, is very clear on that side. This is something that we do. So the first step is develop the plan with counseling-oriented planning partners. So counseling oriented, right? And so if you have financial advisors, planning partners, then that's great. We want them to be part of the process. If you don't, that's okay too. We just need to make sure that that piece is covered by whoever is going to be covering it if you're not around. And then number 2 is commit yourself and your family to a continuing maintenance and education program, or empowering that legacy by having some type of relationship with the law firm. And I'll show you how we do that. So that we can make sure the plan is up to date, and that your key people, or your people that you've designated, your helpers, know what to do at the appropriate time, right? That's the key. And then empowering the inheritance is really step 3, so that when something does happen, we can secure appropriate assistance for you and your family to transfer your wisdom along with the rest of your wealth. Okay, so we're looking at the whole process. All right, so let me give you some education here and some typical traps. The transfer trap, where people want to just, hey, I just want to avoid probate. And we already talked about probate. All right, here's how you get into probate. My engineer clients love formulas. And so if you own anything in your individual name when you pass away, that equals a will. And if a will is the centerpiece of your plan, kind of the main component of it, the hub of it, then there's going to be a probate after. Okay, that's how that works. How do you avoid it? All right, so I'll show you how you avoid it without doing any legal documents at all, if that's all you want to do, but that's short-sighted, okay? You can title things joint tenancy with right of survivorship. Remember I told you there's a couple of different forms of ownership. So joint tenancy, right? Most people are familiar with joint bank accounts. The way that works is that when one owner dies, when one joint tenant dies, the asset will go by operation of law to the surviving owner. You just got to bring the death certificate to the bank, right? And so that is a way if things are titled joint accounts. So let's say we're in a married couple situation and we have everything titled jointly. Okay, so first death occurs, there's no probate, right? What happens on the second death, right? And so we're waiting until the first spouse, we're waiting for spouse to pass away, just statistics, if there's a husband-wife situation, typically the husband's passed first, that we want to wait till the death occurs and then saddle the surviving spouse with all the issues of the things that should have been thought through in it up front. Now we got to deal with not only the grieving, but now I got to fix all this because everything's in my individual name, right? That's a lot to put on. Why don't we just get it taken care of so it's smooth right from the beginning? And then adding, if you're thinking, oh, we'll just add the kids or add, somebody else on it, you don't want to do that. When you add someone as a joint owner of something, you're taking on all their baggage and all their problems. Okay, so if they get sued, divorced, anything, that's all fair game, and they own it. They can take it. So it's not a good way to plan. The transfer on death accounts are basically the financial institutions' contracts. They do have a place in planning, but they are not. I use them a lot with like vehicles and things like that, or places where they won't let you change account numbers, but they need to be titled to a trust or some way. We don't want them going outright to individual names. And you're dealing with the bank's contracts and all their red tape. So you again, take it into your own hands. Don't rely on somebody else. Like I was an athlete playing, in sports. You do not want to leave the hands and the game in the hands of the ref, right? So we don't want that. Usually bad things happen. Planning with the box is box. What I mean by that is if you have, most people have, I've worked with a lot of clients that have 401ks, IRAs, retirement plans. There's beneficiary designations, or if you have a deferred comp plan, different types of things where you have benefit. Those are all doing estate planning. And so you want to make sure you pick the right option, because with retirement plan, money has tax impact. So you need to know what the different rules are by just putting, when you put something in there, know the consequences, right? And that's what a good attorney should be giving you that advice with regard to that. All right, so here are some examples of what I mean by counseling issues. These are some common counseling issues that I find people hit some of them, but not all of them. And so just need to go through, there needs to be a checklist. And we've already talked a lot about catastrophic illness protection. Again, it's a big issue, but let me tell you, some of the issues. So let's say you did have that stroke towards the end of your life. You had that big illness. Do you have an opinion if you'd rather be taken care of at home or in a nursing home, or you don't care, right? And if you do have an opinion, and if it is important for you, where in your legal documents does it lay out what your wishes are? And typically people don't do that. And they say, oh, I've got it covered. I've got a medical directive, right? And I talked to you about a medical directive. It says, you're my healthcare agent, but it's just a list of boilerplate powers. It says you can check me into a hospital. You can check me, you can keep me at home, bring home care in. You can put me into a nursing home. You decide. That's putting a lot of, not only, you may not want them to decide for you. You might have to say, no, this is what I want. Or if you don't care and it's a family, you're putting a big burden on the family on that side. So that is something that you want to be thinking about with regard to disability planning. And the way that we do it is we just have checklists and walk you through it. I just think it's easier to edit than to create, and we'll tell you, and we can document it that way. And so would you rather leave instructions for your own care? That's what that point is. And then the other side of it is, well, what about the checkbook, right? Where you should not be writing. Maybe you've gone past that point where people are taking advantage of you. There's a lot of elder abuse cases that are out there where you should not be managing the finances, right? And so the idea is about control, and our clients put a premium on control. And one client said, "I want to be the one making that decision." I said, "Unfortunately, right? That's one decision you can't make. That, hey, I'm disabled now. Most people, and so the best thing I can give you is give you control on how you give up control of your finances." And the way that we do that is we use a disability panel approach. And there's three main questions. When am I disabled? Okay, and then who can use the money? Who can manage the money for me when I do become disabled? How I define it, and what can they use the money for? And this when is the key point. And so typically it is just two licensed physicians I see that's out in most legal documents. You need a medical component, right? But we also like a family component, because you don't wake up one day and have dementia. And so a lot of times if it's a married couple, maybe we'll have the spouse be on this panel along with the primary care physician. And the decision is, does that person have the ability to effectively manage their financial affairs? That's the question. If there's no spouse, are there kids, or are there siblings, or are there other friends that could? And so it's a disability panel. They're not making healthcare decisions. They're just trying to decide, these are the people I trust to make the decision whether I can manage my finances. And if they say yes, then I don't want to have a court proceeding or a guardianship proceeding of, here, I need to be presenting evidence of my disability. This is going to be a private transfer to my hand-selected person I trust with the money, and here's how the money's to be used. And again, we get you through that with the checklist and the like. So we find that just having a process makes things easier. For those of you who are worried about catastrophic illness planning, has gotten to another level, and this is more Medicaid planning. I'm not going to go too deep into Medicaid planning, but the idea with catastrophic illness with Medicaid planning is, Medicaid is offered through state agencies. Okay, so it's a state agency program. It's funded by the federal government, and I look at it as a payer of last resort for long-term care expenses. Okay, it's a public benefit. And long-term care expenses are expenses that are someone needs to help bathing themselves, eating, feeding. They can't do things on their own. They're activities of daily living. Okay, and so it's not something where you need to go into a hospital. You're either at home and there's someone at home helping take care of you, or they're at an assisted living facility where there are people there, employees there, and that are helping, or you're at a skilled nursing facility where there's an elevated level of care. Okay, and when you have Alzheimer's or dementia, all bets are off, right? The memory care units, you need everything. If you don't have them, and so the idea with that is, in this, it just depends on what area you live in. Like, so for example, if you're in Northern Virginia, for each month of long-term care expenses, a typical, like either having someone come in or go to a facility, depending on the level of care, could be anywhere from $5,000 or $6,000 a month. I've seen it as high as $30,000 a month. Okay, so that blows through people's retirements and expenses. And the way I look at it is, there is what a proactive planning and there's crisis planning. The crisis planning is, you're in the middle of it. Someone is going to the nursing home now, and we're just trying to stop up the plan, right? Obviously, crisis planning, you have less options. I'm a big fan of proactive planning. And basically, in order to qualify for the government, if you're, the problem with the Medicaid is that most people don't qualify. Okay, because you have to have typically less than $2,000 worth of non-exempt assets in your name. I'm not going to go through what's exempt and non-exempt, but basically you have to have basically nothing before you can make the application and get those benefits, where Medicaid will give you some benefits and pay for nursing home. But you're not getting, it's the last resort. You're likely not going to get your own room. Right. And then if it's home care you're looking for, Medicaid does have some waiver programs. You got to get on the wait list for those. It's not 24 hours, so it's not perfect. So these are not great solutions, but they're a solution for it. And if you don't have the ability to self-fund or have already insured some other way on yourself. But with with trust planning, okay, this is a higher level of trust planning, depends on your goals, right? That's why someone needs to know what your goals are before they send you, is now we might have to create an irrevocable trust for you. And that is a way the funds in a properly drafted, you call a Medicaid trust, will not count as resources for public benefit. So we can move assets out of your name for Medicaid purposes. Now, there's a lot of rules, right? There's something called a 5-year rule. Again, I'm not going through that, but proactive planning gives you more options for that. And then someone who understands trust and how they work can help implement that. All right. Remarriage protection, here's another issue. So that's enough about disability planning. For the remarriage protection, it's not about trust between spouses. So let's say I have, I'll have my sample cast of characters, Bill and Mary sample. They have 2 kids, and let's say they have the I love you wills. The I love you wills are very common. It says when Bill dies, everything goes to Mary. When Mary dies, everything goes to the kids. If Mary predeceases Bill, it goes the other way. So let's say I always knock off the husbands first in my samples. You can do whatever you want in your plan, right? Statistics. So Bill passes away, leaves everything to Mary. And let's say Mary meets Bo the tennis pro and gets remarried. And let's say Mary doesn't cooperate, maybe she predeceases Bo, okay? And her will says everything goes down to my kids. Even though her will says everything goes down to my kids, does Bo have a legal right to those assets now that she's married? He's married to Mary. Absolutely, in all 50 states. Okay, and it seems like the theme for most states are moving towards more of a family law component where you say, I don't care what the will says. I'm taking my statutory half. Okay, the max you can get in most jurisdictions is half. It could be a third, depending on length of marriage and the new marriage and the like. And so it's more of a depends on the jurisdiction which you live. But basically, the idea is I've seen it anywhere from a third to a half, where they say I don't care what that is. So that's one issue. Okay, on remarriage. The other issue is, remember I told you how title trumps the legal documents. If you have an IRA, most beneficiary designations on an IRA primary is to the spouse. And so if Mary had an IRA beneficiary designation going to Bo in that situation, then the IRA is going to go to Bo. It's not going to go to the kids. Or if they have joint accounts, it's going to go to whoever. So the titling is the controlling factor. So if there's a way that Bill could leave his assets to Mary, she could use it for whatever she wanted. But when she passed away, it had to go down to the kids. Is that something that's worth spending some time talking about? Okay, I mean, is that counseling? Is that word processing? It may not be a big issue for you, but at least we got it covered, right? We have that issue covered, and why not cover that? Creditor issue is one of the main concerns for a lot of clients, and you just need to understand how that works with regard to creditor protection in the estate planning context, okay? And the way that I explain creditor protection, and also kind of introduce how the trust protection, how a revocable trust works, and the benefits that it uses and what it doesn't do. A lot of people think of, a trust does all this stuff. No, I don't know the differences between the various trusts. I use my school bus story. Okay, so in the school bus story, there's 2 assumptions. Assume that I'm dead in the story, okay? And let's assume that there's no creditor protection for me while I'm alive. So I'm talking about estate planning after I pass. And there's a couple different ways that I could do, that I could have done my planning, that I could have left my assets to my loved ones, okay? Let's say after I pass away, okay? Let's say my spouse is driving and is not paying attention, is on the roads are a little slick, runs a red light, bam, hits a school bus full of kids. Let's say horrible facts. Let's say one of the kids dies, there's going to be a judgment against her, there's going to be a big lawsuit, it's going to wipe out whatever, it's going to be more than any insurance that I could have had or left, and it's going to wipe out the estate, right? So it's a catastrophic creditor. One of my clients said, Bobby, you should don't use school bus full of kids, use school bus full of lawyers. You get more sympathy. And so, but the point of it is this, she hates herself, right? The world's against her. There's not, the idea is just a bad situation that we're in. And so there's a couple different ways that I could have left my assets to my loved ones, okay? And so it could be anybody. It doesn't have to be, you don't have to be married to the person. So the idea would be, I could have done a simple will. When I die, I leave everything outright to my spouse. They hit the school bus, they have creditors. All those assets I left, they're gone. They're subject to her creditors. Second way I could have done planning is I could have just titled everything jointly. Remember I told you about joint bank accounts. So everything's joint and it avoids probate, but now that all those assets are outright in her name, can the house be, can they put a lien on the house? Absolutely. Can they do a bank garnishment, take the bank money? Can they enforce those judgments and take everything that was jointly held? Absolutely. So there's no creditor protection with joint accounts. Third is by contract, right? I could have done a life insurance policy that turned in, let's say I have $1 million policy and I wrote in the beneficiary designation form, that box I was telling you about, write the spouse's name, and I pass away, $1 million gets dropped into the account, into their account, they hit the school bus, gone, right? All that money's gone. Fourth way is these simple trusts or bare bones trusts that I see. It says, when I die, everything goes outright. Same problem, okay? So let me do my planning again. So let's say I did it this way. Let's say that when I pass away, I can leave my assets to my loved ones. They can use it for whatever they want, but if they hit the school bus, it's protected from their later creditors, okay? So let me say that one again because it's important. They can use the assets for what they want, leave it to them, but when they hit the school bus, protected from their later creditors. So remember that definition of estate planning act. And I want to make sure you're connecting the dots here. Remember that part where we talked about, I want to give what I have to whom I want, when I want, in the way that I want. So how many of you would like to leave your assets to your loved ones that way, protected from their later creditors? So how many of you have been asked that question before? Is that counseling? Is that just word processing? Right? So I'm trying to get a theme across to you is just get with someone, because there's a lot of issues out there that someone should be checking off. And so how does that work? How can you do that? So the way, you just need to understand how a revocable trust works and an irrevocable trust. So I can create a revocable trust for myself. And a trust is basically a contract. You're all three parties to the contract initially. You're the trust maker. I created the trust. You're the trustee, you're managing it, and you're the initial beneficiary. And a revocable trust, we're looking at it, is this like this Yeti cup? It's just an open cup. I can get in and out of it, and my creditors can as well. So a revocable trust is not going to give you any creditor protection. Remember that story? I don't have creditor protection when I'm alive. But when I pass away for my estate planning, I can say, put the lid over it and say, this is my hard-earned wealth for my beneficiaries. It's not for my beneficiaries' creditors or spouses. With their money, you can do whatever you want. This is my money. And so I don't want to give it to their creditors. I want to give it to them. And that's how you do it. All right. Through the trust planning on that. And then, and so that's after death side of things. A lot of people say, Bobby, that's great that we can do that. And that's an option that the attorney should go through with you and explain. And if there's some wealth to protect there, that makes a lot of sense. They say, but Bobby, can you do that for me now while I'm alive? I want the creditor protection for me. Yes, okay, you can. It's just a different level of planning. It's more advanced, it's goals. A lot of my doctor clients or people who are really high net worth are worried about getting sued and the like. You can do that. It's just understanding how the trusts work. And it's just a specific way. So it's more advanced. It's not a typical type of estate planning approach or a basic planning. I've been doing a lot more of those lately, but it's just a matter of if that meets your goals and the like. Divorce protection is really, I don't spend too much time. It's just the issue of how would you like to assure that the assets that you leave to your beneficiaries, so you leave your wealth to, stays with them. The wealth stays with them rather than go with any new outlaws, any new divorces and the like. And values promotion, I just used my babysitter story. If you have any, if any of you have kids or ever hire a babysitter, I have a 6-year-old, so you know, the idea is when we just kind of go out for one evening for a nice relaxing show, right? And you hire the first babysitter, one person's out and letting out the rules. So, you know, she's going to want to stay up late. If you make sure she brushes her teeth. If you read this book, read every page, because if you skip a page, she knows. I don't know how she knows, right? We're going to be here. Here's the neighbor's information. Here's our stuff. So the point is we're making all these instructions and we're just going away for one evening, right? For dinner or show. Would you agree that we leave that, those types of instructions for just one evening? And we leave more than that. The point is, we leave more instructions when we're going away for just one evening for a dinner or a show than we even think about leaving in our estate plans when we're going away for a lifetime. Sorry, I got a little bit tongue-tied there. But the point is, again, I'm not going to say, give me your values. I have a checklist that we go through if there's sports to it. And a good attorney, I think, should just go, I call it like the trip to the eye doctor. Here's issue one, and kind of narrow down the issues and we co-create the plan together. So that's counseling. That's kind of an idea, gives you an idea of what the counseling issues a good estate planning attorney, I think, should go through. The next is having some type of maintenance component, some have a type of relationship with the attorney. And so commit yourself in your family to a formal maintenance and education program. So early on in my career, I would focus on, hey, there's going to be changes, in your life. There's changes in the law. And there's even changes in estate planning techniques. And people get that. They just I was focusing here. They wanted me to focus on, well, how does the money work? Okay, am I gonna have to pay you hourly for all this? And so, I do not want to nickel and dime the clients. I just want to say, here's the value. If you see it, great. If not, that's fine. It's an optional maintenance plan. And so the bullet points for the maintenance plan are here. Make sure I'm sharing my screen again. And so the maintenance plan goes as follows. There's no additional charge for phone calls, emails, faxes, and letters. So, if you have a question or concern, call us. The way that we do it is we do phone appointments. My light went out. We do phone appointments and we know the issue and we just schedule them throughout the week. And so we're not playing phone tag, we cover it, and our phone's not ringing off the hook for that. Word processing amendments, right? So someone moves, someone's name changed, that's part of the deal. Oh, I forgot. The annual maintenance plan is $725 a year. Okay, so it's a flat fee of $725 a year for basic planning. Okay, obviously, if you have a Medicaid planning or advanced planning, we customize it. For most people, though, that's the number. And then, so there's word processing amendments. This one is a big one. Annual funding double check and ongoing funding support. Okay, what the heck does that mean? And so in the estate planning world, estate planning attorneys, this word of funding is important. So you need to understand it. Funding basically means, it's not like in the traditional sense, I'm funding a deal, like I'm putting 100,000 into. No, it's funding is how are all of your assets titled. Okay, and so it's a very tedious part of the estate planning, but it's so critical, because if you don't get one asset titled right and it needs to go to court, guess what? You're going through probate on that. And so it's an all or nothing type of deal. We have to have everything right, because I don't want to go to court. Okay, and I haven't had to go to court on any cases that we've done. So if you're vigilant on the funding, then you're going to be in good shape. And so that is the one time-consuming part. And so people just, when you're comparing fees and the like, that is something that attorneys typically will leave to the client. And we manage that process because the stakes are too high. Because if you get it wrong, then the plan doesn't work. And so this asset report is one of our main tools that we use. We have two main tools that we use at the firm. And I'll explain why. It makes a lot of sense. And I'll show you both of them. This is the first one. It's the asset review report. So this asset review report we send to our clients each year. And so every year they're going to give us the new values so that we can be aware of if there's going to be a tax issue or if there were going to be a Medicaid issue, we can get in front of something. And then we're also, and the way that this is structured, I'm not going to go into the details, but this means that the new owner is Bill or William's Revocable Living Trust. That's the acronym. And a check mark means we verify, we have a piece of paper in the file verifying that, okay? Because you do not want to have a situation where the bank says, no, it's titled this way, and you have no evidence to go back at them. Investment accounts, your stocks. So we want to mark by each one beneficiary designations on your retirement plan. So we don't look at the ownership of a retirement plan because you're the owner, but we're going to make the beneficiary designations and what's the best one for that. Okay, so that funding report each year we send out, and if there's new assets, you give us the new assets so that we're not playing Sherlock Holmes to go find everything if something happens to you. It cuts a tremendous amount of time and expense off of the estate administration and ensures that we avoid the probate process. Okay, huge benefit. That in itself is worth the annual fee. But and then ongoing funding support. I'm opening up a new investment account. Okay, we'll work with your advisor. Or you're buying a new real estate. Okay, well, this is work with the title company should have the deed for, right? And so we want to make sure that going forward that we get things covered. The family meeting is not every year, okay? And that's just year one, we'll do it at no additional charge. And that'll be, you can do it further on. Some people take advantage of it in future years, but that's an additional fee for that, typically at $500. But the idea with the family meeting is I'm going to go over as high level or as detailed as you want with whoever you want on the level, the plan. All right. So who needs to know the 911 information, who we are, level of detail we can get a deal with. Every year we have an annual group client meeting. Okay. COVID made the group side of things be Zoom basically. And we just did I do the annual client meetings on Zoom now, at least for the foreseeable future. And I'm doing them in January and February. So I did one last week. I have one tomorrow, and I wrote the outline so I can tell you, basically what I talk about in those meetings is I go over big picture what's going on with the law. So I gave basically a synopsis of what all the darn laws that went through last year, the elections, where the things are going this year, what's pending, and what you need to be aware of with regard to it. I go over different estate planning techniques that are out there and things that we may be incorporating into your plan. Going through the estate planning, any changes in our personnel process that we have. So it's about an hour and a half to 2 hour meeting, depending on the amount of updates. And that's a group, big picture one. Every 3 years, we do group document updates, and that's at our client update programs. Those are smaller groups. And so a lot of now we do is I'll give you the education through Zoom. Here's the updates in the legal documents. And then we have a tool that we provide to you, our second main report that says, give me any personal updates. This estate planning review worksheet is your executive summary of your plan. The trusts are longer. This cuts down everything to about 20 pages. And the key people, the key providers, my disability panel, my beneficiaries, my healthcare agents. Do I want to make a change? So this is your way of communicating personal changes to the plan while we're putting some of the legal updates. Oh, they put a new tax provision in that needs to go into all the plans. So we put that in. Digital asset issues are now something have changed. So we need to put digital executors in all the plans. And so those are the group client update meetings. And we do that every three years. So things are being updated consistently. We have group educational programs. The one that's the most widely attended one, I call it nuts and bolts one. What to do when a loved one becomes disabled, what to do when a loved one passes away. I go through the basic process overview, give them the 911 information that they need to know. If something happens, this is what we do. Here are the steps. I do that program is Saturday before Thanksgiving every year. I do it live, and also it's recorded for our clients on our website as well. DocuBank membership is like having your medical directives online and with you at all time. And so your medical, if you get into an accident, and so I didn't bring my wallet into this room, you get a little credit card and it just stores your medical directives. They can be accessed 24 hours a day, 365 days a year. We also have a portal as well that keeps all of your legal documents stored digitally as well. Okay, so a lot of benefits for the $700, and the idea is we provide a lot of value. The renewals are actually coming in right now, and so we're at plus 90% renewals. We have some stragglers out there. We're typically over 95, 98%. We have very little attrition on the maintenance plan right now. So asset review report, kind of a summary, that's part of the maintenance. The estate planning review worksheet, kind of your personal instructions, the annual client meeting, and then the update programs, and then just family education trainings. Those are just sprinkled throughout. And that's kind of the overview of the maintenance. And so the third step is, hey, let's secure appropriate assistance, right, to transfer my wisdom along with the rest of my wealth. So when we're talking about appropriate assistance, what does that look like for you? For a lot of our clients, it's, hey, let's make sure the costs are controlled. Let's get full disclosure of the costs so that we have true peace of mind. So now we're going to start focusing on, you know, how you control costs. We'll talk about costs and fees at this point now. So one way, hopefully I'm kind of filtering major concepts to you. Hopefully one way that you have learned, or I'm going to make sure I stress it to you, is that one way is to full funding, right? Fully fund your trust. We know what that means now. It means everything is titled in the trust. That controls costs so that when there's a death, okay, we're not going through probate, we're passing that box off, or that cup off to the next person in line that we've handpicked. There's going to be an administration, okay? And I'm going to make sure you understand this. Death is a major life event. We have to close out all of your relationships, all your issues, okay? But we're not on the court schedule, okay? So that's good. And I'll go into a little bit more detail later, but that's number one. That's the way to control costs. Proactive trustee and beneficiary training. So the people who are your backups or receiving any of this stuff, right, or to be helping manage it, if they have some idea of what to do or process, that makes things go easier and smoother and reduces costs, right? So that's why we have that family education side. And then we have a proactive engagement approach. Is if you're on our maintenance plan when you pass, we'll agree to do the administration at predetermined rates. We're not locking your family in. We can't. Some people want us to. I can't ethically bind them. They would have to, the successors that you've designated, they have to hire us, okay? We'll be the cheapest people. We'll say, hey, we set it up. We know where everything is at, boom. But they don't have to use us at that time, okay? So that's a way of controlling costs. Let me show you, let me get into the numbers now. Just again, kind of focusing on funding because that's something that's typically missed. And that's why the fees are changed, because most people will say, oh, you do the funding, and it never gets done. Or one or two assets get title right, but something comes up at work, or there's a health issue that you get slowed down and it just doesn't happen. And that's the problem. And those assets that don't get title right go through the court process. So funding is getting everything managed and put it into the trust the proper way. So full disclosure of the costs. So every estate plan has 3 sets of costs. Okay, most people focus on the first one. They don't realize the other 2. All right, so they say the cost of the initial counseling and documents, that's kind of where the market kind of thinks, and that's where but they're not looking at the cost of updating or failing to update, or the cost after death. Most of it's back end loaded because nothing is done right. And so let me show you the typical administration fees that are out there. I'm just going to show you Virginia, Fairfax County here. I'll show you Maryland too. There's a Maryland one, and I'll show you a Florida schedule. But the idea here is just understanding there's no exact number. There's just, these are guidelines. These are published guidelines by the court. If you go over these numbers, you better give the commissioner a good reason. If you're within these numbers, it's usually a rubber stamp. Here you get what you statutory. And so most jurisdictions are reasonable compensation states. I love how they put that in quotes here. And so what is reasonable compensation? So this is if you're going through probate. Okay, so this is why I want the will-based plan, I want the probate, okay? Then, or there's assets that were not titled properly in the trust that have to be probated. These are the fees that what an attorney can charge to do the administration on the probate side, okay? While the assets are tied up in probate, if there's income being generated, CD, interest, dividends, any income that's being generated from business, 5% of those income receipts, that's a reasonable fee. And then the principal. So the underlying, if you have $1 million worth of assets going through probate, the first 400,000, there's a 5% fee is reasonable. The next 300,000, 4% of that, right? So you get the idea is that these percentages, you just multiply, right? 20,000, 12,000, 9,000. So, and so most people don't like those percentages because they're pretty big, right? And so do all attorneys charge this? No, some will charge less, some will charge more, okay? But those are the guidelines with regard to it. I usually find that it's usually at the maximum level. Loudoun County is the same as Fairfax. Here's Montgomery County, Maryland. Maryland. So you got to look deep into the code so I know where to go. These, you should have these too if you're maybe it's like too much overwhelmed. But the idea is to let you know these are the fees that people don't look at, right? So if you have a $1 million estate in Maryland, the first 20,000 is charged at 9%, and then the remaining 980,000 can be charged at 3.6%, right? So that's Maryland probates. So then also in your packet is Florida schedules. And the reason why I put Florida schedules in here is for two teaching purposes, okay? Florida is kind of the mecca of estate planning. It's kind of, so, you know, there's a lot of seniors down in Florida. Some people call it God's waiting room, right? And so there's a lot of trusts that are in Florida. There's a lot of well-developed trust law. And so the people, the legislature, the consumer protection side of things, they said, look, when people pass away, attorneys need to start putting a cap. There needs to be a cap on what an attorney can charge to do a trust administration. All right. So again, I'm teaching you. So the probates are through the courts, and those are court supervised fees. I showed you those. But if you create a trust and we're not going through probate, then there's still an administration. So a lot of people think, oh, I did a trust, there's no administration at death. No, death is a major life event. Okay, every one of your assets there needs to be closure on it, transferred, taxes paid, closed out, whatever. Think about how many usernames and passwords you have. Not that we're going to ever get them, but think about all of your accounts. What do you know? What happens to all those? How many do you have, right? And so everything needs to be bound up. And so there's going to be administration. It's just that we're not having to go to court, number one. And then Florida being such a strong consumer protection state developed in the trust law side of things gives you an idea of what an attorney can charge, a cap on what an attorney can charge to do a trust administration. Okay, it's not a public record. That one's private. Probate fees are all public records. You can go down to the courthouse and pull them up. And so that paragraph 3 is basically saying an attorney can charge 75% of what they could have charged at a normal probate. So basically with the trust planning, they're saying you get a 25% discount. Okay. Florida schedules, I put these schedules in for you so you see them, are lower just because Florida is a strong consumer protection state for seniors. But if you have $100,000, if you have a state between 100,000 and 900,000, they're at 3%. Okay, so it's less than that 5% you saw, and then 2.5%. So you get the idea. It's a percentage deal, probably more than you ever wanted to know. But that's the basic way that typical administrations are charged. Here's how we do it. Okay, there's I call it, this is the investment selector. So you have two options. I don't care which option you take. Most people, I'd say 95% plus, take the fixed option, but if you find the variable good for you, good, fine. So we just talked about death and what administration fees are. There's setup, maintenance, and after death. After death, we just saw 5%, 4%, 3%, right? If you're on our maintenance plan, we'll agree to cap the administration at 1.25% on the size of your net estate. That's only charged at death. It's deducted from the estate, and it's only if we're hired, okay? But we'll say we'll do it for this. And the reason why we're less than half of those schedules you see is because of the maintenance, right? And so if I have a fully funded trust and I don't have to go through court, that should make my job easier, and that should translate into a cost savings, right? If I have an educated family that followed the process, knew what to do at the right time, that makes my job easier, translates into a cost saving. If I have a planning partner, you have a financial advisor where back offices are in sync with all of the paperwork that we're pushing back and forth, that makes my job easier. If I have updated legal documents, right? Updated, consistent with the latest laws and your instructions, makes my job easier. That's the $725 fee that I went over with you before, okay? The $1,000 to enroll in the maintenance plan, we charge a little bit more, the $275 more, to verify everything we did up front, okay? As part of the counseling and design fee, which I'll get into, is not only the setup of the legal structures, the documents, but we're also going to coordinate all the funding, okay? So we submit all the paperwork, get things in order, work with you because you got to do the work benefits. But part of the enrollment fee is, hey, we got to verify everything that was done in step 1. There's a piece of paper in the file. That's a high standard, okay? Jenny Oliver, our funding coordinator, is responsible for that. And so in our, our files, we've got verifications of all of that. That's what that means. Okay. Again, it's optional on the maintenance side of things, but we're not going to honor we can't honor any of these back ends if we're not doing that. So the setup fee is 1/2 of 1% on the size of the net estate, subject to a minimum of $4,000, a maximum of $12,500. Where you land depends on your assets, your goals, what you're trying to accomplish. You don't get charged anything until we know exactly what we're doing. We do it on a project fee. Here's the flat fee, and we decide whether we want to do it or not. And then the maintenance is integrated after, where we're setting up the trust and funding everything. That's for base plans, okay? So if you have Medicaid issues or have advanced planning, creditor issues, things like that, you're going to be advanced planning. And so we're going to need to make modifications. This is kind of like the home base structure, okay? This is a big picture of how we do. The variable option is a little bit less upfront, 1/3 of 1% on the size of your net estate. Still, our minimum is 4,000. The maximum is 12,500 on that one. And then the back end we charge on the first tax coupon, we'll charge 2% rather than 1.25%. What's the first tax coupon? So I'm not going to get into too much on estate taxes. I told you I would. Currently, there's a federal estate tax coupon what you can die with. And so without having to pay any excise tax, there's a 40% excise tax if you go over the estate tax coupon. Right now, the coupon is as high as it's ever been. It's $12,060,000. You have to die with more than 12 million before that tax is triggered. Okay. And so if you're married, we can double that with proper planning. If you're over that amount, good for you. We're going to do some advanced planning for you. Okay. Most people are below that. Now, that tax coupon keeps changing though. They were trying to move that. Congress was trying to move it down to 5 million January 1 of this year. They couldn't get that through. Okay. There were some issues in the elections, and a lot of those bold proposals got pared back. But in 2026, the law is automatically scheduled to sunset to go to 5 million. So without Congress doing anything, it's going to go back. So maybe 12 million doesn't apply to you, but maybe 5 million does. Maybe 5 million doesn't apply to you, right? But you have to someone needs to be watching this for you. That's what that means. So that's the basic set of fees. The two questions that my engineers always ask me is, what if something happens to you, Bobby? Right? I have more people worried about my health and welfare than I've ever had in my life. And so I would not be a good estate planning attorney if I didn't have a good succession plan in place. Right now, I have an external succession plan with, he's one of the bios in the packet that was sent to you. Ed Clay, he teaches with me at the National Network. He's agreed to take over my clients. If I get hit by the bus, and I've agreed to take over his, we follow similar processes until my internal succession plan has formalized. So a few more years, a couple of the associate attorneys need a little bit more under their belt before we can get a formal one in place on that one, but that's coming. And then the 725 fee, will it ever go up? Yeah, but it doesn't go up. It's only gone up once in the time that we've done this process from 2007. No, twice. Okay, so every few years, but it went up $50. Okay, it's not going to go up $1,000. So we've got about 280 families on our maintenance plan. And so I don't want people all mad at me for that. It is mainly a lost leader to go back to your clients every year, review the files, right? Most firms are just finding new clients. We're reviewing the file, make sure stuff is done. Hey, we need this verification. We need this. Okay, so less clients. The idea, this is my kind of business model. It's like less clients, because I'm not like a will mill where I'm just trying to get as many people in as possible. Better relationships, more detail work, more preparation. The maintenance side of things, the maintenance residual revenues, those are coming in now. That reduces stress for the team, knowing that they have a position that they're doing well. It's optional, so it's not locked in. So if they're not doing a good job, right? So the client, the team really takes that to heart. And we're getting referrals, and we really pride ourselves on having plus 90%, 95% renewal rate. And then the settlement and administrations are very predictable as far as the families. Every family has hired us. They don't have to. It just makes sense. And this is why we do it. We're looking at the whole kind of picture. So that's the fee side of things. Hopefully it was educational for you on that. The main thing is, I'm a Paul Harvey fan. He was a radio announcer. I'm kind of dating myself. What's the rest of the story, right? So you want to ask the attorney, what are the rest of the fees? When they say, oh, it's this for a trust. Well, then you say, okay, well, how much are you going to charge me to fund the trust, right? Are you responsible for that, or are you me? Because that's a lot more time consuming, okay, when you compare or what are you going to charge my family on the trust administration? If they say, I don't know, say, here are my assets. Here they're titled this way now. I die tomorrow. What are you going to charge me? And you may not like the answer on that. Do you include the death tax returns as a part of the settlement fee? That's part of our deal. And death tax returns are becoming more and more necessary because of this legislation they passed called portability, beyond the scope of today, but it's a tax, an estate tax concept that, in order to protect your coupon, even though you don't have a $5 million or $12 million estate, to protect that prior spouse's coupon, just in case something happens, you need to file this, this complicated return, which we can do, and that's part of the deal. This is my little trick question is, how would you charge for probate services, right? If the trust attorney is going through a lot of probates, then that should be a red flag to you. Okay, we do probates, not on cases that we've done and set up for trust. It's usually we're taking on those cases. I used to do more. We do less and less because probate is such a pain to deal with, and all the forms that keeps coming out and the delays. And so general summary, costs after death. Remember, the traditional probate is those fee schedules that I showed you. The living trust planning is those Florida fee schedules with that 25% discount. We've done a review of our plans. Like ours is for the whole life of the plan, because we're proactive, is 1% to 2% for the whole life of the plan. Okay, so that's that. So controlling costs, full disclosure. Hopefully that gives you true peace of mind. This is how things will work out. This analogy with the whole iceberg is just kind of giving you the comparison between traditional planning that's out there and the modern approach. I think most attorneys are trying to start to move towards there. The traditional is you get basic documents and questions answered. The modern approach is so much more, right? It's the counseling that we talked about. It's the funding, okay? Hopefully you understand that term now. It's the maintaining it. Disability events we talked about. The surviving spouse issues if you're married. And so those are big. Let me show you our process chart, and then I will go back to that questionnaire that I started out today and then answer any questions that anybody may have. Coming up about close to, it's 11:15, so we still got time. So our process is as follows. And a lot of people ask me, how long does it take, to get this stuff done? Well, it just depends on what you mean. As far as documents in your hand, if you're motivated, then we'll get through that process usually in 6 to 8 weeks, depending on just calendaring. And then the funding process takes a little bit longer, but you've got things in place. We're just waiting for things back from the court or financial institutions. So where you're at is the truth about estate planning is the initial one. That's today. It's about an hour and a half. It's with me. There's no charge. If you're saying, hey, I'm interested in exploring further, then you opt for the discovery dialogue. You let Michelle know. Michelle will ask if you want to do the discovery dialogue. That's with Wendy Masimer, our associate attorney. There's no charge for that. You would complete your personal information form ahead of time. She would review it. She would do a goal setting exercise with you. And she would say, here are the fees that you're looking at for what you're trying to accomplish. Okay. If you're motivated and you want to get it started, she has the engagement agreements there. It's called the initial interview. That's my little stop sign where we have specific fee quotes, go over scope of services and the like. If you need to think about it, that's why I have that little line there. Think about it. You come back and we decide whether we want to work together or not. If we decide we do want to work together, then we'll have a counseling and design meeting. That's usually 2 to 4 hours. I would never keep you for more than 2 hours typically. We break that meeting up. That's where that critical thinking goes through, right? That's where we want to make sure we're clear on your instructions, disability, transfers, all those things, taxes. And so we'll spend time there. And then the next meeting after that is a delivery and review meeting where we'll review the legal documents with you, make sure you understand them, answer any questions you have. And then a lot of times we're doing that through Zoom now, and then we're just having a separate signing meeting where you're coming in, signing everything. We do have a digital portal as well. So you would get all of your estate planning documents digitized as well on your portal, available at any time. And so that's where, a lot of people say that's, a lot of planning stops there. That's not the end. Okay. So now we have to make sure your assets are integrated. So the financial strategy meeting is where, and that's usually delivery and review meeting, 2 to 3 hours typically. The financial strategy meeting is an hour or two. Again, that one is where we'll sit down with you and any advisors that you want, financial advisor, or anybody you trust. Make sure that your estate plan is coordinated with your financial plan. Make sure we have an accurate inventory of everything. Make recommendations on what we would do. If we see other strategies out there, we'll throw them at you as well. And then once everyone agrees to what we want to do, then there's a funding meeting where Ginny will have all the magic forms to get everything titled properly into the trust. Okay. And then there's an optional family meeting. As I said before, there's no additional charge as long as it's done within 1 year of you signing the plan, or we'll go over the plan as high level or as detailed as you want with whoever you want. And then you're just on maintenance. Okay. So it could be done within 6 to 8 weeks here. If you're like in a crisis situation or you need to be acting quicker, we can do more of a special delivery program if necessary. Kind of put you on a fast track. There's a special kind of schedule for that. It just depends on your situation, right? And then you're just on maintenance, like I talked to you about before. I think I see. Okay, so someone asked me a question. So if it's about 4K for revocable living trust plus if it's complicated. So that's the 4K is a minimum, okay? It depends on your goals and the assets, okay? And what you're trying to accomplish. And again, I would say, what's the level of the estate? What are your issues? Here's what the fee would be. And then you would decide whether we want to work together or not. But yeah, just level of complexity, right? What are we doing for you? So the questions that I would be asking the estate planning attorney, let's go back here. This is what I would use, okay? Say, what's your interest, background, and experience? What percentage of your practice is in estate planning? So this is intended to see, is this their focus area or are they just dabbling? This is what we do, okay? There's enough to it. I would ask them how they define estate planning. Remember how we define it: control while healthy, plan for disability, give what I have to whom I want, when I want, in the way that I want, all while assuring my wisdom is transferred along with the rest of my wealth. What's your counseling philosophy? Remember, you teach us the family, we'll teach you the law. Make sure we focus on family first and then what the lay of the land is, and then make recommendations. Once I know your situation, here's what you need to do, or here's my recommendation for you. What's your process for working with me, right? I just showed you the process chart. I just find process produces predictable results. And how will you counsel with me to design my plan? The way I'm kind of doing it now, I don't know if that's good or bad for you. Stories, I talk pretty straight. I'd be happy to talk the legalese with you if you want. Most people don't want the legalese. How do we ensure that my assets are controlled by my instructions contained in my planning documents? This is the important one, right? So that's the funding question, right? Who's responsible, you or me? So most of the times it's you're responsible, client, and that stakes are too high and it's very tedious and time consuming. You saw that asset report. Everything's got to be verified on that, okay? But that's what it takes. How do we assure that my plan stays current with changes in the law? Ours is the maintenance plan. What's the level of involvement of my family in the planning process? Again, depends on family dynamics. My experience is that there with more transparency and communication, things go easier, but I understand family dynamics. That's not always possible. How do you charge for services, right? So I just specifically, how much will my estate be charged after I'm gone? So I just went through ad nauseum at that so that you understand how these are laid out there. Be happy to answer any other questions on that. What is your record with regard to probate? We haven't had to on any of the clients that we had a full probate. It's not a guarantee. I guess it's bragging rights. But this is a good way of saying, hey, do you charge differently for those? So it's basically, if you're a trust attorney and there's a lot of probates that you're going through, that's something's wrong, right? So it should be quiet in your office. Like our office, it's really is getting paperwork taken care of, managed. We're not going to court, litigating. We're not doing that. I'm not worried about opposing counsel. Okay. The handling, do you handle the filing of the death tax returns if they're necessary? Yes. It's part of our administration fee. What if something happens to you? That's my succession plan. How do I prepare for our consultation? You would do the personal information form. What type of service should I expect from you? So for us, it's more, you're gonna benefit from working with everyone on the team, right? So, you're gonna be working with Ginny, Wendy, me, Michelle. Everyone's got a different value. Holly, Bonnie. I mean, there's different issues. Depends on what we're doing. What type of do you expect any commitments from me? Basically, just do the personal information form. Think through some of these issues. You don't have to know them. That's what the attorney's there to help you work through them. But when it says who will fulfill the necessary helper roles, the helpers of what we're doing is building a succession plan. These are the people that are your backups in different areas, right? There's a healthcare backups and financial backups. It could be the same person, but it may not be. There's different qualities for a healthcare agent. They need to be someone who's going to honor your wishes, ask the doctor the tough questions, be a patient advocate. The financial side is more being just a good manager and being able to analyze the financial situation, file the tax returns, and dealing with the financial institutions. Think about the goals that are most important to you that I went through. I went through a lot of stuff. Is it disability planning? Is it minor children? Is it tax planning? Is it smooth transfer of wealth? Do I have a current inventory of assets? Remember, this is a big part of it, is knowing where everything is at so we can get them over to the right place. What advisors can I involve? I think a financial advisor, if you have one, is a great one to involve with that because they have all the access to the wealth, at least the major assets. So that's it. That's it for today. I was right around an hour and a half, a little bit less. So with that being said, I will look to see if there's any other questions. But again, on the fee side of it is, that's the ranges, 4 to 12, 5. You'll know what you'll get before we start doing anything, because we both have to agree to it. Okay. That is it for me today. So with that being said, what was the max on the fixed? The max is 12,500 on the fixed side of things. Any other questions? I'll hang out for about a minute or two. And then I will conclude for today. Hopefully you got some good information. Hopefully y'all are staying safe out there. What we're doing is we're an annual client meeting on our side. So I'm waiting to see what the Senate is doing with some of the legislation that's pending out there. So kind of where we're at on our side, and we're on our annual client meetings. Very good. Oh, there's another question. What happens if we move out of our state of residence? Great question, because in the Northern Virginia area, at least, it's very kind of a transient area. And so there's a couple options. First of all, if the trust is the hub of your planning, the trusts are contracts and they're portable from state to state. All right. So there doesn't need to be a whole restructuring unless you go from, like, let's say you come from Virginia to California. Well, they are different tax states. California is a community property state. Virginia is a separate property. So then we might need to do a little bit more work in the trust, but typically the trust portable from jurisdictions. It's those ancillary documents that are state specific. And those usually need to be updated in a year or two, like your medical directives. That needs to be state specific. Your powers of attorney, those are state specific, and we coordinate that. And if you wanted to maintain, stay on our maintenance plan, we have clients, that are able to do that. If we are licensed in that jurisdiction, anybody in our core firm, then we'll be able to manage that. If we need to go and do a co-counsel agreement with one of my colleagues in the national network, where they'll bless the documents for the state specific, then we can do that. So It just depends. We have actually a memo on it for our clients that do it, because when they move, they could stay on our maintenance plan or go onto another attorney's maintenance plan or jump off of it. With Zoom and with a lot of the video conferencing, we're able to do a lot of things in the digital side. Do we provide services if we were on the receiving end of someone else's estate plan? Yes, definitely, because we've done enough administrations where I know how I would like things to be done ahead of time. I wish I had that. Because usually when it's too late, when people come, like, oh, we got to fix things. But yes, that's the best place to do it, is ahead of time. Absolutely. And I'll hold on for one more minute before I conclude. Good questions, though. I'm glad people were listening. So. Okay, very good. I will conclude now. Thank you very much. Michelle will reach out to you if you want to take the next step. Have a great day, everyone. Bye-bye.